This case is already spiraling before the judge even speaks: a bond violation, a no contact order, a marriage license filed after an arrest, and a defendant who says seeing her son broke her. Sin, what you're about to hear isn't just a legal argument, it's a collision of emotion, accountability, and court orders that were very clearly laid down. And as this hearing unfolds, one question looms large: when personal heartbreak clashes with the law, how much grace should the court really give?
We're here for a pretrial and a bond violation. We're ready to resolve the bond violation. She will admit to the allegations of contact, and would like to provide the court some context, if you would allow that.
Go ahead.
Your Honor, I do admit I was wrong. Let me start there. I was wrong. When I got out, I thought that she was going to be at her mother's house. And when we went to arraignment, they said she's going to be at her mother's house and I could return to my home. But I didn't know until the end, when they were releasing me, that I could not return to my home. So that was a surprise. And I called the police like I was told to do. She packed up some of my stuff. She left our marriage license on the front of my driver's side. I didn't know we were married, Your Honor, because we had gotten married a couple of weeks before, and we had talked about not filing the marriage license. And so she filed the marriage license after the incident, and I did not know that we were married until she left it on the seat. And so when I did call, she had packed it up. She'd packed up my stuff. I did leave, but then I realized she didn't give me shoes. And so I called the police officers back. I was away from the house. I was down the street. I was trying to do the right thing. They got called an emergency, so I was waiting longer, and I saw my son get out of the car, and I saw her pull the trash cans up. I did not approach them. I did not try to approach them. But when I saw my son, that's what broke me, is I saw my son. And so I did violate, Your Honor, I did violate, but I was not aggressive. I did not approach them. I did not come near them. I did send text messages, but I didn't understand with the marriage license and it broke me. My son broke me. That's why. And I wanted to know if there was hope. That's all. And I do acknowledge I was wrong. I do learn, and I will not contact her again. 100%.
I will add, Your Honor, she has been in custody for about 5 days, I believe. If she were to be released, she would be staying at a hotel nearby. The house was recently flooded, so she actually has funds from the VA to stay somewhere else. There's work being done on the house. So given her admission and her owning up the fact that she did violate the court's orders, I'd ask that you sentence her to those 5 days.
What are we doing on the pretrial?
We're asking for an adjournment
Right.
on the pretrial.
Do people have something to say in this?
Yes, Your Honor, we would object to that. Given the nature of these texts and the fact that they were sent, she was, I believe, arraigned on the 22nd, sent these immediately after getting out and being told not to have contact. And in those messages, directly acknowledges that she was not to be having contact, continuously telling the victim not to contact police, and then sending other manipulative messages to the victim, intending to make her feel bad for contacting the police or trying to contact police.
When's my next day?
May 13th.
May 13th.
Yes.
I'll adjourn the pretrial in this matter to May 13th. At that time, I'll also sentence her on the bond violations. on that May 13th, and then her bond at this time, given what I've seen here, her bond will continue as revoked. And
Yes, Your Honor.
thank you.
Teresa Blair on behalf of probation. Your Honor, Mr. Anderson is before the court for a violation of probation hearing. Mr. Anderson violated his GPS tether that he had on. He entered into the exclusion zone, including going to the victim's residence, and also took her vehicle. They then tracked the GPS where he removed the tether and left it in Flint. Mr. Anderson failed to enroll in the domestic violence program, and he failed to continue to report as he should. I would also like it known to the court when Mr. Anderson walked in and up to the podium, he was looking, trying to make direct eye contact with the victim who is present today. Your Honor, given the violations of Mr. Anderson and his clear non-compliance with what this court ordered, probation is asking that the court sentence him to 93 days in jail, credit for 33 days that he served to date, to serve the balance, waive remaining terms of his probation, accept his financial obligations, and discharge him from probation without improvement.
Ms. Coons.
Your Honor, my client would like to admit to the violations with explanation. I think that he is very apologetic about his actions. He just lost his sister and he's grieving right now. He's not in the right state of mind, and he understands that he has made some poor decisions here. As to the no contact violation, he had news that the complaining witness was possibly selling his stuff. He does understand that the proper remedy would have been to go through civil court after discussion with him. And particularly to the vehicle was in both their names, but again, I did discuss the civil court with him. As to the lack of payment, it's due to a lack of monetary funds. His sole source of income is from Social Security. He's been homeless since the beginning of this case and just fell on a hard patch in life. And that goes for the domestic violence program as well as to why he didn't complete that. In addition, he did not have transportation. So, Your Honor, we would leave it inside the discretion of this court as to the recommendation, but we would ask for some type of leeway on account of him just not being in the right mind state. He's grieving and he just lost his sister.
And Your Honor, I just would also like to make it known to the court. I had a meeting with Mr. Anderson. It was made extremely clear where he could and could not go. So it wasn't discussion made about the truck, as he indicated that it was in both of their names. He was told what he needed to provide to this court if that he wanted to pursue that. Just taking it upon himself and leaving his daughter's home where he was staying in Detroit and coming here and going to her home and taking a vehicle was against what he was instructed to do. He knew full well that he should not have been in the exclusion zone, period.
Anything you want to say, sir?
I came down here when I seen her, and I have friends here that I've been, and I understand that when I talked to you, you made it clear to me 5 miles. I understand that. But she told me that the police don't have time to be running over there to see about my things, and that I shouldn't come.
She who?
The lady that was just talking.
Ms. Polera?
Yeah. And that you said not to even come to Washtenaw County at all. And I'm like, you know, she wrote it on this paper. So, Your Honor, I'm just.
Well, why'd you take the GPS tether off then?
I was going through some things. I lost everything. I was wrong.
Oh, I know.
And I understand. I mean, I was going through some things, Your Honor, with this whole situation.
Court will accept the admission to the violation. Court will follow the recommendation of probation. They will waive remaining terms accepted as financial obligations, discharge him from probation without improvement. Sentence you to 93 days, Washington County Jail. Credit 33 served. Defendant is to serve the balance. I'm not even going to consider an early release. Thank you.
Thank you.
All right, sir.
This courtroom exchange reveals something the justice system grapples with every single day: the line between personal hardship and legal responsibility. Both cases presented here, the court wasn't asked to decide whether emotions were real. It was asked to determine whether court orders were followed. And the answer in both situations was no. In the first matter, the defendant openly admitted to violating a no-contact order. While she framed her actions through confusion, emotional distress, and a deeply personal moment, seeing her son, the court had to evaluate behavior, not intent. No-contact orders exist to prevent escalation, confusion, and emotional manipulation, even when contact feels justified in the moment. The prosecution emphasized that the defendant acknowledged she wasn't supposed to reach out, yet did so anyway, sending messages that the court characterized as manipulative and aimed at influencing the victim's actions. That acknowledgement matters legally because it demonstrates awareness of the restriction before it was violated. The defense highlighted mitigating factors: 5 days already spent in custody, temporary housing plans, financial resources from the VA, and repairs being done to the home. But the judge's response was clear: bond conditions are not optional, and immediate violations after release are taken seriously. By continuing the bond revocation and scheduling sentencing for a later date, the court signaled that accountability does not pause for emotional turmoil. Then we move into the second case, where the pattern becomes even more concerning. This wasn't a single lapse, it was repeated noncompliance. A GPS tether was violated, an exclusion zone was breached, a vehicle was taken, the tether was removed, and probation conditions, including a domestic violence program and reporting requirements, were ignored. On top of that, the probation officer noted behavior in court itself, attempting to make eye contact with the victim. In a courtroom setting, even non-verbal actions carry weight. The defense again pointed to grief, homelessness, lack of funds, and emotional instability following the loss of a sibling. These are real struggles, and the court acknowledged them, but they do not override court orders. The judge emphasized something critical here: the defendant had been clearly instructed on where he could and could not go. He knew the exclusion zone, he knew the rules, and choosing to remove a GPS tether is not an emotional mistake. It's a deliberate act. Ultimately, the court followed probation's recommendation: 93 days in jail, credit for time served, remaining probation terms waived, financial obligations enforced, and probation discharged without improvement. And notably, the judge made it clear there would be no early release. That statement alone underscores how seriously the court viewed these violations. So, what's the bigger takeaway? Courts can and do consider personal hardship, but compliance is the foundation of any conditional release. Bond, probation, and tether agreements are contracts with the court. Break them, and the consequences are swift and often unforgiving. Now, here's the question for you. Do you think the court struck the right balance between compassion and accountability? Should emotional distress ever justify violating a court order, or does that open the door to dangerous precedent? Drop your thoughts in the comments, because this is exactly where legal responsibility and human emotion collide. And if you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.